Hi everyone, thanks for being here. I know there's still some folks trickling in and people joining online. Olivia, are you able to hear me or not yet?
Yes, I can hear you great. Are you seeing the presentation the way that you want it to be seen?
We are seeing the presentation, and I think this means that folks online are also able to see both the presentation and the person who's presenting. But if you're online and that's not working, if you could do the raise your hand or something so we can figure that out, that would be helpful. Oh, should I turn it on?
She said she could hear.
If they can hear us, great. Yeah, that's true. I hope some more in-person folks trickle in, but thank you for those of you who are here. And it's really nice to be joined. We had over 120 people register for this training. So it's great to see that there are so many folks who are interested in learning more about our work at NIJC, the National Immigrant Justice Center, and particularly about how we represent LGBTQ asylum seekers. My name is Charlotte Saul, I'm the Pro Bono manager, and I'm joined by 3 of my wonderful colleagues who will introduce themselves, as well as one colleague, Olivia, who's sharing screen and joining us remotely. We are super grateful to McGuire Woods for hosting, and for those of you who are here in person, there will be a reception right after the training today. I'll also flag up front that this training is being recorded and the materials will be online in the next couple days. So if you're not able to join for the whole time, or if you missed anything, those materials will be there. And for anyone who's interested in taking on a case, we will also be circulating the list of cases for which we're seeking representation. Those of you in the room, there is that list right in front of you. Olivia, you can just go back to the beginning. I think other people are running this part. Yeah, thanks. So I'm going to hand it over now to my colleague, Katie McCoy, who will get us started. And thank you again for being here.
Hello everyone, thank you for being here. Just so you know, there is CLE credit that we'll be giving for today's training. It is for folks who are licensed in the state of Illinois, and it is only for folks who attend this training live, either in person or remotely on the webinar. We will give 2 different codes, so pay attention to those, write them down. It will be recorded and posted on our website, so you can watch this at your leisure. If you missed something, you want to go back to something, but only for those attending live will be eligible for CLE credit. So let's go ahead and get started. Our agenda for today is, oh, sorry. Olivia, there we go. Yes. Can we go to the next slide, Olivia? Thank you for your patience with our change in plans and how we're presenting it back. But I think it's all running.
Olivia, can you go to the next slide, please?
There we are.
Perfect.
Great. Okay. We have an action-packed agenda, which is why we are trying to keep things going despite some technical difficulties. So we are going through everything. We will have a 10-minute break so that 2 hours does not seem too long. Everyone has a moment to stretch their legs. We are going to do an overview of asylum law and the asylum law that exists in today's world. This is to assist folks who are representing asylum seekers. This is not meant to be for folks practicing unauthorized or doing unauthorized practice of law. This is for attorneys and folks working with attorneys on cases, and it does or should not be used as a substitute for your own research and evaluation of someone's case and understanding of the facts at hand. Next slide. Great. Okay. I am one of today's 3 presenters. My name is Katie McCoy. I use she, her pronouns. I am a senior attorney on the LGBTQ and asylum teams. My colleagues right here will also, I'll let them introduce themselves. I think if you just speak loud enough, they should be able to hear you.
Sure. I'm Jules Vance. I use they, them pronouns. I'm the paralegal on the LGBTQ team.
My name is Henry Zhu. I use he, him pronouns, and I'm a scan fellow of the team as well.
And Olivia Judd is our managing attorney. She's monitoring the chat. She's here remotely. So folks on the chat, you'll be mostly communicating with Olivia, and then in the room, we'll be communicating with you. Next slide, please. Okay, NIJC's mission. The National Migrant Justice Center has been around for a while and we have decades of experience of providing full services in immigration law. We are a nonprofit organization dedicated to ensuring human rights protections and access to justice for all immigrants, refugees, and asylum seekers. We aid low-income individuals at free or low cost, and our offices are nationwide, mostly focused in the Midwest, primarily in Chicago and Indiana, but we do have small offices in Washington, DC and San Diego. The National Migrant Justice Center is a little bit unique in our approach in that we do not only direct services, but our direct services help inform our systemic immigration reform policies and advocacy. So we have an advocacy branch, the folks that are in DC, but also here in the state of Illinois doing advocacy statewide or at the local level, and a litigation team that helps with mass litigation and direct or impact litigation on new policies or trends that we're seeing impacting the folks that we work with. So it all kind of informs each other in a very robust and dynamic way. Why does legal representation matter? Asylum law, immigration is a civil matter, so no one is guaranteed an attorney to defend them at their asylum merits hearing, for example. And that really matters because there will be an ICE attorney against someone and arguing for their removal. And so to have a legal advocate explaining and helping someone navigate these incredibly complex areas of law makes a huge significant impact. In fact, 2.5% times more likely to win a case with representation rather than without. We do know that currently denial rates are on the rise, so it's even more important to have someone defending due process rights while they're going through these different proceedings. So what does it look like if you were to accept a case? So first, someone makes contact with NIJC. They say that they are looking for representation. They're looking for support on their immigration case. And NIJC will then do the screening to determine whether someone is eligible for some sort of relief. And we first identify them so you wouldn't have to. And then we would say, hey, you look like a great candidate for a fit with the pro bono team, and would send you the information and a retainer and any sort of thing that you might need in order to effectively and competently represent that person throughout their immigration case. Our model is a little twofold. We have clinics that allow folks to have maybe one-day interactions with people who might have more limited needs or might need more form-based forms of relief, where it's a DAPA renewal, it's an application for a work authorization. And then we have more labor-intensive or longer-term investment in clients' lives, working with clients, which would be an asylum application, working with folks who are detained, maybe on bond release, U visa and VAWA for victims or survivors of domestic violence and other crimes, trafficking survivors. And then somewhere in between those both models is the special immigrant juvenile status, which is a little bit more limited, but not quite. It's not as short as a one-day clinic, but it's not quite as long as an asylum case. So it's usually the family-based protection in state court law, receiving a parental order for someone so that you can then do the immigration part of the case. Our partnerships, they are unique in that we will handle the technical side. We will handle providing you templates. We will handle providing you any sort of strategy ideas. We have intel on different judges. We have advice on current trends. And your job then is to really build rapport with the clients you're working with so that you can have those interactions, get to know the person, and defend them as an individual as best as possible. We cannot stress enough that you do not have to have prior experience in immigration law in order to take on a case. And you don't have to have prior experience as a litigator either. Immigration law is a little bit more unique. Immigration court is a little bit of the Wild West where rules of evidence don't apply. They're just persuasive. And so you don't have to feel like you know every single thing about being a litigator. We will give you the tools and help support you so that you feel confident in representing your client. Why does this matter? Representing an asylum seeker in particular can really help change the trajectory of someone's family history, where their future, where their children, where their family members get to live safely. So it is a one-for-one model. If you take on a case, that allows NIJC to take on one more case in-house. So it has a huge ripple effect. And it also helps preserve positive case law in the Seventh Circuit. We monitor that closely to make sure that immigrants' rights are defended, not just at the IJ level, at the immigration judge level, but beyond that as well. So how do you get involved? We have a website full of resources, like this training will be posted to our website afterwards. We have sample document banks, FAQs, practice advisories. We have a manual that is incredibly in-depth and often answers most questions that our pro bono attorneys have. It should be the first place people look, and we're coming out with updated versions very, very soon, so stay posted for that. Why an LGBTQ asylum case in particular? It is a very scary time for a lot of our clients where their identities are being attacked and basic protections are being erased and eroded. And so to have someone defending them while they're navigating these multiple different attacks on just being who they are as a person, as a trans person, as a queer person, as an immigrant, certain nationalities in particular are being targeted. It is all the more important to have defense to protect these due process rights and uphold basic human rights for all of the people who are navigating these systems. We know that the Trump administration in particular has attacked trans folks and had a number of executive orders that are erasing their ability to be themselves. And this has had an impact on our clients as well, including in the policy manuals, making it unable for folks to identify with their gender, reducing the forms to only be aligned with someone's sex assigned at birth. And also folks who are detained are so much more vulnerable based on the sex they are assigned at birth. They are not recognizing care for transgender folks and erasing protections against discrimination for sexual orientation and gender identity. So having an attorney, like I said, can have a real significant impact. We put together a list of 8 cases that our goal is to have those placed by the end of this training. And these are just a sample of these cases. And I will share logistics at the end if you are interested how to contact us and sign up to represent one of these individuals. Now I'll pass it to my colleague, Henry.
All right, thank you, Katie. So before you really get started with your own asylum case, we do want to go over a bit of asylum law. Again, this is a very high-level summary of asylum law, like all immigration laws, and exceedingly complicated. And this is just meant to give you a brief overview of everything. We'll go through the basic elements of asylum law, and we do want to emphasize that this is an area of law that y'all might have seen in the news is changing drastically. So this is asylum law as of today. It may change. There will likely be a lot of change that will happen in the next few months or years, and we will help keep you updated on those. So to start with, I think just to level set, we do want to provide the basic definition of asylum. Asylum is a form of lawful immigration status that lets someone eventually get permanent residency or green card and have a pathway to citizenship. And it's available for anyone who meets the definition of a refugee. The most important part of that is here in green, which is that the person has a well-founded fear of persecution, which is a legal term, on account of 5 specific reasons: race, religion, nationality, political opinion, or membership in a particular social group. This is based on international law and it's codified in the Immigration and Nationality Act at the section there. And then, so the asylum system is rather complicated, but it kind of breaks down at the highest level into 2 buckets of cases. If we can go to the next slide there. So there are, you'll hear both affirmative and defensive asylum cases. Affirmative cases refer to individuals who are not in court yet, and they are not, the government is not seeking to remove them or deport them to their home country. Instead, they are proactively applying for asylum by submitting a form to U.S. Citizenship and Immigration Services, that's USCIS, and specifically their asylum office. These cases are adjudicated via an asylum interview with an officer, which is not necessarily adversarial and in theory more trauma-informed. And individuals who do not receive asylum through that process then are referred to immigration court to start immigration proceedings, and those are defensive cases. So defensive cases are ones in which the government has already determined that this person is not in the United States with any kind of lawful immigration status and seeking to send them back. That is a adversarial process, involves litigation. There is an attorney who represents the Department of Homeland Security or ICE, as you might have heard, Immigration Customs Enforcement, who's arguing that the person should be sent back to their home country. And then you, as the person representing the immigrant, would be arguing that they qualify for asylum as a defense deportation proceedings. We would want to flag that these cases are in immigration court, which falls within the Department of Justice. It's an administrative agency governed by administrative law judges, who are not Article 3 judges in the traditional sense, but instead fall within the purview of the Attorney General. So then, so most cases you'll take will be at the immigration judge level. You'll go to, if you take a defensive case, we have affirmative cases as well if you choose to take those. But the focus of this training today is on defensive cases. Those you'll present the case to an immigration judge or an administrative law judge in within the Department of Justice, and then depending on how that goes, either the non-citizen or the government can appeal that decision to the Board of Immigration Appeals, which again falls within the Department of Justice. It's staffed by the Attorney General appoints attorneys that are staffed to the Board of Immigration Appeals, and then after that, if you receive an adverse decision from the Board of Immigration Appeals, then you get a federal court review that goes directly to the federal courts of appeals, depending on where the immigration judge was sitting when they decided their case. So here we have immigration courts in Chicago and Indianapolis. Any decisions from those immigration judges go to the Board of Immigration Appeals, and any appeals from there go to the 7th Circuit. If you're in San Francisco, the 9th Circuit, and New York, the 2nd Circuit, etc. And from there, it can go to the Supreme Court if necessary. So then, as with any kind of interaction with federal agencies, it's an alphabet soup of acronyms. So what we were just kind of discussing before was the Department of Justice and the immigration courts. They fall under the agency is called EOIR, which is the Executive Office of Immigration Review. If you take a defensive case, you'll mostly be interacting with attorneys from this agency that includes the immigration court, where the immigration judges sit, and the Board of Immigration Appeals as well. The prosecutor, the ICE attorney, actually falls under the Department of Homeland Security, which is, as everyone knows, separate from the Department of Justice. And then the Department of Homeland Security is what houses U.S. Citizenship and Immigration Services, which is the agency that adjudicates those affirmative applications through the Asylum Office. ICE, Immigration Customs Enforcement, also falls within Homeland Security, as well as CBP, which is Customs and Border Patrol, which is the folks who are kind of interacting with folks that come in at the border or at airports. So these are kind of different government agencies you'll interact with. There's also, if someone comes here as an unaccompanied children, which is not really the focus of this training today, but NIJC does have those clients as well and has a pro bono project for them, they would be placed with the Office of Refugee Resettlement. So that's a different agency with its own process as well. And then, of course, finally, there are the folks at the center of these proceedings, the asylum seekers themselves, their families, and you, the attorney, would kind of serve as the liaison for the immigrant and all of these various agencies that they have to navigate. So just a little bit about asylum law on the next slide here. It really breaks down in terms of the INA is the main statute that you look at in any asylum case. That's section 208 of the INA, and then the other section is listed here as well. From that, you have the Code of Federal Regulations that kind of explain that are promulgated by the agency and explains a little bit more in detail with certain rules and regulations about motions, etc. And then, of course, interpreting the INA and the Code of Federal Regulations or case law, because immigration is an administrative process. The Board of Immigration Appeals, which I mentioned on the other slides, sometimes will publish precedential decisions that is binding on any immigration judge you interact with, unless it's been rejected by the federal circuit, the federal circuits that review them. Similarly, the Attorney General can refer decisions from the Board of Immigration Appeals to him or herself, change the result or change the analysis. That's similarly binding. But those cases can then be appealed to the federal courts of appeals, here especially the Seventh Circuit. And the Board of Immigration Appeals decisions are usually not the most friendly to our clients, but the Seventh Circuit in particular has declined to follow a lot of them, and we expect that to continue with our help, of course, and with your help litigating these cases. So we definitely suggest really taking a close look at Seventh Circuit case law. If your case is here in Chicago or in Indianapolis, if it's somewhere else, you have to pay attention to the circuit there. And be careful in citing out of circuit case law, because the circuits have split on a lot of different issues in immigration law, and Seventh Circuit law is going to be much more favorable to your client than, for example, Fifth Circuit law. So in terms of how the asylum process actually works, this is the start of the process is filling out the form I-589, which is the application itself for asylum. There's actually three kinds of relief. There's asylum, which you usually hear about, and then withholding removal, which is another form of relief that doesn't allow the person to get a pathway to citizenship, but prevents them from being sent back to a specific country where they might be persecuted. Similarly, there's protection against the Convention Against Torture, which basically says you can't send someone back to a country where they'd like to be tortured. It's important to apply for all three, and we do know that at the time you would take an NIJC case, this form has probably already been filled out and been submitted, but you can amend this form before the hearing and before you submit your materials in case your client's situation changes or the job changes, they have kids, they get married, etc. So before we kind of get to the substantive areas of asylum, we do want to flag a couple of things that might make your client ineligible for asylum even if they meet the other requirements. One thing is that per the statute, an individual who is seeking asylum has to apply within 1 year of arriving in the United States. There are exceptions to this rule that for LGBTQ clients in particular that involves coming out, gender transition, PTSD. NIJC has briefed and argued these issues in terms of the exceptions. So that is definitely something to keep in mind, and we will help you if this is an issue, but this is something that anyone taking this asylum case should be aware of. Similarly, another issue that sometimes comes up and perhaps will come up more is what's called firm resettlement. That's the idea that if this person who is applying for asylum received an offer of permanent residence, that's important, permanent residence in another country before coming to the United States, then they are not eligible for asylum. That means if someone from, let's say, Brazil went to Colombia and actually got permanent residency in Colombia, then they wouldn't be eligible. Again, there are exceptions to this, and NIJC will help you brief this issue if necessary. And then statutory withholding is something I mentioned a little bit earlier. Is another form of relief that if your client does not qualify for asylum because they filed after a year or they had an offer of permanent residence from another country, they might qualify for statutory withholding. It's called this withholding of removal under the Immigration and Nationality Act, which is different from withholding of removal under the Convention Against Torture. And this mostly tracks the elements of asylum as well. The main differences we would want to flag is one, it's mandatory, which means if your client qualifies and meets all of these elements, then the immigration judge must grant this form of relief, whereas in asylum it is discretionary. So the immigration judge can deny in their discretion, although there are some limits on that discretion. Another thing that we would want to flag with statutory withholding is that it is a little bit tougher to get. It requires a clear probability, that first point of persecution, rather than simply a well-founded fear, meaning you essentially have to convince the judge that it's more likely than not that this person will be persecuted if returned. Otherwise, the elements are mostly the same. We do want to flag that the on account of standard, meaning that the persecution has to be because of one of the protected grounds, is a lower standard in the 6th or 9th Circuit. So if your case ends up there, for example, you change venue because your client has moved somewhere, that's something to note as well. So this may be something that comes up increasingly as administrative policies change and they try to institute more bars to asylum. We do want to flag that withholding removal is the idea is that the judge issues a removal order and then they literally withhold it. So that is statutory withholding. Similarly, another form of relief is relief under the Convention Against Torture on the next slide. There's two forms of relief there. It's either withholding removal or deferral of removal. And for purposes of this training, you should just know that the difference for Convention Against Torture is that torture legally means something more extreme than persecution, so it's harder to prove. But the upside of that, there's no what's called a nexus requirement. You don't have to prove that the torture was on account of a protected ground or anything like that. And another difference is that the torture has to be with the acquiescence of the government, which again is a higher standard than asylum, which you just have to show that the government was unable or willing. And the burden of proof, again, like for withholding of removal, for the Convention Against Torture, you have to show that it's more likely than not that your client would be tortured. So again, a tougher form of relief, and also no pathway to citizenship with this form of relief either. So here kind of just summarizes the differences between these forms of relief. Again, always apply to all of them, because even though asylum is the preferred form of relief because it leads to citizenship, sometimes your client might not qualify for it because of the bars we mentioned. Sometimes withholding of removal is easier for that nexus reason in certain circuits, and for Convention Against Torture relief, there's no need to prove kind of ties to a protected ground. So it really is important to apply for check all forms of relief and make all of those arguments. So that I know is a very quick and dirty summary of some of the basics of asylum law. Now Jules will touch on working with LGBTQ clients and competency in that regard.
Thanks, Henry. As we go into the rest of this training and talk a little bit more in specific about the legal side of things, we wanted to start off by providing a shared grounding in our understanding of our clients' activities and some basic terminology. Go ahead and go to the next slide. I want to talk about three broad categories that are going to be helpful to us here. And it's important to consider that although these may impact one another, they are distinct. This is starting off with the bottom corner here, gender identity, which is sort of an internal question. This is something everyone has to figure out for themselves. It's a question like, do I feel like a woman? Do I feel like a man? Neither, both, either, or. There are as many gender identities in the world as there are people in it. And so this is something that is very expansive and also often quite internal. It might determine how you want to present yourself. Maybe you want to dress in a way that is more feminine. Maybe you want to change your name. Maybe you want people to use different pronouns for you. But it is something that every individual comes to a decision about of their own accord, both in terms of how they want to identify to themselves and in terms of how they want other people to refer to them. All of this terminology, I think, can be quite intimidating, especially to people outside of the LGBT community, but also to those of us that are in it, because it's often changing. And this will be a recurring theme throughout this section, but always ask to clarify. Someone is going to be the expert on their own identity, and you're not going to be able to figure it out any better than they have. Similarly, this also goes for sexual orientation. As opposed to gender identity, which is mostly about you and how you feel, sexual orientation is more about who you're romantically or sexually interested in. I'm combining the two for the purposes of this. So you might be interested in women only, you might be interested in men only, you might be a lesbian, you might be gay, you might be straight, all of those things fall into this category. And then finally, in the bottom here, we have the question of biological sex, which is something that gets talked a lot about in the current political climate. For the purposes of this, I'm not really interested in focusing all that much on this. As legal advocates, we do sometimes need to know this about our clients and understand how it impacts their lives. But this is a category where I'm going to advise caution when it comes to asking questions, because it can get pretty invasive. But this includes things like what sex someone was assigned at birth, meaning when you emerged from the womb, a doctor looked at you and decided that you fit into one of two categories, male or female, or that you were intersex, and then even so, they usually assign you one of the two. This does impact how people live their lives, and for example, if you're assigned one, you might be transgender and decide to transition to a different set of hormones or any number of things. But again, as legal advocates, this is the category that we least need to be involved in, and our claims are mostly going to be focused on the gender identity and sexual orientation of our clients. I'll take the next slide. I'm going to talk a little bit specifically about competency in working with our trans clients, and honestly, this goes also for trans people in your life, I think, in general. Transgender meaning, I suppose I'll give a broad definition, someone who does not identify with the gender and sex they were assigned at birth. It is absolutely crucial for folks who are transgender to consider using, not to consider, but to definitively use the name and pronouns that they choose. This is the baseline of respect for working with these clients. And if you have trouble getting it or you make mistakes, that's fine. Just correct yourself and move on. And even if you find that you're having trouble with it, find someone to practice with who's not the person whose pronouns they are. That can be very helpful in just getting the muscle memory going. Also, I'm going to define some terms down here that will come up in working with trans clients. Gender transition or just transition, the process of changing aspects of yourself to affirm your gender. This is a really broad term. It can be social, it can be medical, it can take the form of hormone therapy and all the stuff we're going to talk about here, but it can also literally just be coming to a realization about yourself and deciding that for yourself with no external change. It could be a social change. It could be asking someone to use different names, it could be changing the way you dress, or it could be a medical option, for example, hormone replacement therapy, which is when you use or inject exogenous hormones to change your body's systems, or gender confirmation surgery, which is a broad term referring to a variety of surgeries that people use to change their body in a way that they prefer their body to be. Next slide. So in working with clients, I'm going to provide some examples of language here of how I might go about navigating these conversations. If a client uses a particular language, then reflect that language back to them. Again, allowing them to sort of take the lead on discussing this kind of thing. If they refer to themselves as gay, then say, okay, when did you realize you were gay? Or how long have you identified as gay? Don't use terms that they did not themselves use. Certainly don't use terms like homosexual, which kind of carries this like negative medical valence. If your client is gendered, non-conforming, or trans, ask about, do you use any other names? Do you have a nickname that you prefer? And then even if they are a little hedgy about it, I always find that people tend to be very affirmed and happy if you go with the nickname, even if they were sort of hesitant to tell you. And lastly, if you're unsure about pronouns, ask directly. Sometimes this needs to be explained to people, but it's worth explaining to say, how do you prefer to refer to you? How do you want me to refer to you? And then also, in noting, one more thing on the last slide. In noting all of this, you want to make sure that you understand who they're up to in their lives and who they're not. So for example, if you're working with someone's parents, they may or may not know. So check in with your client in a private setting about who knows about particular names, who knows about particular pronouns, and how they want to be referred to in different scenarios around you. Okay. Thank you. Here's just some basic, more general tips about affirming LGBTQ identities as you work with clients. Get comfortable with the basic terminology. Google's your friend. There's a lot of resources out there. We've listed some at the end of this section. The client is the expert on their own identity. Like I said, that's a great rule of thumb. If a term comes up that you're not familiar with, engage with respectful curiosity. Ask to clarify, but don't. I think there's a point at which it becomes like invasive to ask a huge line of questioning. So find out what you need to know in order to refer to this person and then move on. And of course, when mistakes happen, correct yourself briefly and move on. So all of these are best practices for working with trans people and queer people directly. But of course, as legal advocates, we also have to engage with the legal system and the exigencies involved there. We have some preferred language that we and our circuit court and the legal precedent that we have set will lean towards. So for example, we want to use terms like person living with HIV as opposed to someone who's HIV positive, person first language is preferred there. We want to avoid terms like homosexual, transsexual. These carry, again, a negative valence. Instead, we would prefer to use transgender. And again, now I'm talking in terms of writing a brief for another formal document. Transgendered with an ED at the end is also kind of an improper way to refer to people. And finally, as a matter of technicality, as opposed to sexuality or sexual preference, we will say sexual orientation, which I'm not a lawyer, but my understanding is that this, we don't want to say sexuality as it implies some mutability to this characteristic, which is of concern in the asylum claim. And lastly, not on this slide, I should say, it is our job as legal advocates to navigate between the client's identity and the words that are understood by the court. These are not always the same. Sometimes you will need to make a compromise. Always open a discussion with the client about how you're going to refer to them, both in person and then in court. Also, in addition to working with queer people, we are generally working as legal advocates with queer people who are from a different cultural background than ourselves, as is often the case. Again, always ask clarifying questions when needed. Don't shy away from that just because you think that it might be improper. If you need to understand something, you need to understand it. There's often an argument made that gender identity or queerness is an imposition of the West on the rest of the world. This is not a great understanding of that. Gender and sexual diversity exist everywhere. They are, however, discussed very differently and understood very differently. So if there's a particular word in the client's native language that they use that may not quite work or that you don't understand, again, just clarify. I've included some examples here of places where Spanish and French language speakers in particular might use a different term. Homosexual, or the French equivalent, is often used to identify by people to identify themselves, but we might want to explain to the client that we're not going to say homosexual in English because it carries maybe a different connotation. In the interest of time, go ahead and head to the next slide. So in general, and looking back, familiarize yourself with the appropriate terminology, practice using the terminology that your client uses. Also, and this is tough, recognize that you are going to have to talk about some pretty sensitive subjects with your client. This is always going to be true in an asylum case. You're discussing with people the most traumatic things that they have been through, most likely. But it is important to the case. It's important that you understand it well and that you're going to represent it correctly. And when you have to have these conversations, be sensitive, be human, be empathetic, but be direct. Don't tiptoe around it. You're going to have to talk about it. And I'm going to discuss a little bit later in this presentation some tips for making sure that you're providing a comfortable environment for your client to do that. And lastly, think before you ask questions about specific sex acts or body parts unless you really need to know. Sometimes you do, and that sucks, but most of the time you don't. So it's important to be cognizant of that. People are sharing very tender things with you, and you really need to be cognizant of that and to open space for them to do so without being invasive. This slide just contains a list of links if you want to refer to some guidance on all this terminology stuff, which I will leave here, and this PowerPoint will be provided to everyone after the training. And I'm now going to hand it off to Katie again to go into some depth about the elements of asylum.
Thank you, Jules. Okay, so this next section is going to sort of marry everything you learned from Henry and everything you learned from Jules. So you're taking on an asylum case. We're going to really break it down. What does that look like? What are the elements? And we're going to pair that with our LGBTQ client, so you know what you're looking for when you're taking on a case. These are the 5 elements that Henry already outlined for you. That someone has a well-founded fear of persecution that would be perpetrated by the government or an entity the government cannot or will not control on account of a protected ground. And most often, we're in the last one, membership in a particular social group. These are separate elements. I cannot state that enough. Please do not conflate these elements. You have to meet every single one of these elements. I say this because sometimes judges like to conflate the elements. Sometimes the Attorney General likes to conflate these elements. Sometimes circuit courts like to conflate the elements. And it can get really confusing, and then they'll tell you that you didn't meet the elements while they're conflating them. So make sure you know exactly that you have every single element met. Okay, the first element, fear. And it's kind of strange that this whole form of relief is based on an emotion, the emotion of fear. And it is the client's burden, the respondent's burden, to show that they meet this standard, that it's their burden of proof that they would experience a reasonable possibility, which honestly is 1 in 10 chance. It's relatively low that they would experience persecution. And that's established 2 ways. One, based on everything they suffered before they came to the United States, and they've met all 5 elements already in the past, or they have a reasonable possibility that this would occur in the future based on the 5 elements again. We always encourage arguing both. both past persecution and future persecution to protect all grounds of relief. Sometimes judges like to just grant on future persecution, but that's why you're preserving all arguments, so you have everything in there. What this looks like specifically for past persecution, if you'll go to the next slide, Olivia. Thank you. For past persecution, like I said, it's all 5 elements. So in the past, they were persecuted on account of a protected ground by either the government or someone the government couldn't control. And then this creates a rebuttable presumption of future persecution. At that point, the burden shifts to the government. And so then they could rebut this by saying, if you were to return, the circumstances have changed, meaning like, oh, there's new laws that protect LGBTQ people, there's a regime change or something like that that would make it safe for someone to return, or saying they could live somewhere else in the country and not experience the same kind of harm because internal relocation is an option. Importantly, internal relocation needs to be safe and it needs to be reasonable, not just possible, it has to be reasonable given all of the factors. And so often for our clients, that usually means probably nowhere in the country is accepting of LGBTQ people, so probably nowhere in the country would they be safe and able to internally relocate. And so then if you're on the future fear base, you have these sort of 3 aspects that you're using the 5 elements within, that the fear is subjectively genuine. This is important because this goes to your client's credibility, that they're telling their story and the way that they're expressing their fear, what they think would happen, that the judge is believing it. Credibility is a huge part of an asylum case. Objectively also, given all the circumstances, given the country conditions, this is likely that this would happen to this person, that they would experience persecution. And then again, that there's nowhere in the country they could relocate to avoid this kind of harm. That's the standard for future fear, well-founded future fear of persecution. Right? Persecution. Okay, so persecution is defined by case law. So pay attention to your circuit, pay attention to the 7th Circuit in particular, because it's really good. So there are typically 3 different types of harm that count as persecution. Physical force, this is, I think, what everyone probably thinks of first and foremost when they're thinking of persecution. Then infliction of comparable physical harm. This could be some form of torture, deprivation of different types of like food starvation if you're in detention for a long period of time. And then third, non-physical harm of equal gravity. So that's usually psychological harm. Or, which is very often used in our cases, an inability to be open with someone's sexual orientation or gender identity. Forcing someone to abandon their protected ground is a form of persecution, and that's well defined in many circuits, but especially in the 7th Circuit. It is important to know that harm persecution is a higher standard than mere harassment or mere discrimination. So you have to show that it's more pervasive. The homophobia that someone is experiencing is so pervasive, so taxing, that it is rising to the level of persecution. And keep in mind that persecution for a child is a lower standard than for an adult. Other things that maybe might not immediately jump out to someone as persecution, but there is case law defining it as persecution and shows up often in our cases. Rape and sexual abuse are forms of persecution. Conversion therapy, even if someone is sent to conversion therapy under the guise of it being good for them. That doesn't matter if they're not intending to harm someone by sending them to conversion therapy. That is a form of torture. That is a form of persecution. Also, forced marriages can be a form of persecution. And as I was mentioning, inability to live openly or pervasive homophobia do count. They are a little bit harder, but they are factors you should be considering, especially because all persecution, all forms of persecution must be considered cumulatively. So build out everything that someone has experienced in their life, and often it's a lot, and use that to make sure the adjudicator knows past persecution occurred and is likely to occur in the future. So now we have a hypo, and I'm going to read it aloud the first time. It's going to be the same hypo throughout, so you don't have to keep getting used to new facts and issue spot. But this time, while I'm reading it, please pay attention to what facts are important for persecution, what that I just explained to you could constitute persecution. So Bernadette, who uses they, them pronouns, is a queer non-binary person from Colombia in removal proceedings. Bernadette was assigned female at birth and generally perceived as a woman while living in Colombia. Around 2021, Bernadette began volunteering with a Colombian organization that works on advocating for LGBTQ rights and HIV prevention. Bernadette taught sexual health classes and sometimes helps the organization with administrative tasks. In 2022, neighbors obtained photos of Bernadette and their girlfriend being affectionate together after Bernadette's girlfriend took her phone to be repaired at a local shop. Bernadette's parents forced Bernadette to marry a man who prevented Bernadette from leaving the house, beat them, and raped them. With the help of their sister, Bernadette escaped Colombia in 2023 and flew to Mexico. Bernadette spent 1 year in Mexico where they received a temporary work permit. However, they felt forced to hide their sexual orientation and gender identity and did not live openly as a queer non-binary person. Also, they were repeatedly called anti-LGBTQ and xenophobic slurs by strangers on the street, and on one occasion, they were attacked and robbed by a man using such slurs. In early 2024, Bernadette fled to the United States and timely filed for asylum. So folks in the chat, if you wanna identify what is persecution, and I'm not going to cold call, but I would love if someone in the room has an idea of what any of these facts might be that rise persecution, or if you could argue as persecution. Yeah.
The forced marriage.
Yes, forced marriage, that is definitely a form of persecution. What happened after they were forced to get married?
Someone put inability to live openly in the chat.
Yes, okay, yes, great. So we are issue spotting what rises to persecution, and this ties in a little bit to what Henry said. When you're framing the asylum case itself, you want to pay attention to their home country, because you don't want to argue the same facts for resettlement. They did not have status in Colombia, or you would be arguing that the status that they had in Mexico is not a permanent form of status, it's a temporary work permit. But yes, you would say that that harm is a form of persecution. Yeah.
They face both physical and non-physical harm in when they were forcefully married to their husband. They were both beaten and sexually assaulted.
Yes.
And then in Mexico, they were non-physically harmed by xenophobic and anti-LGBTQ slurs.
Great, absolutely, yes. Those are exactly what we would argue. In Colombia, the forced marriage, and then what happened after they were forced to be married to a man. And then in Mexico, this would go to the firm resettlement argument, but for sake of identifying what counts as persecution, yes, being forced to hide sexual orientation and gender identity, being called slurs is good evidence of harm that is pervasively homophobic or transphobic, and being attacked and robbed in the streets. So, great job. We'll move to next, who is a persecutor? So, as I said with the elements, it's either the government or an entity that the government is unable or unwilling to control. Government identity, it does hit all the things that you would think it would, police, security forces, but it is a little bit more expansive. So in a country that is ruled by gangs, think about whether that could be a de facto form of government. And then, as it says in red in bold, the persecutor does not have to be the state, it could be a private actor. So think about the family that's potentially doing harm, or schoolmates is a common one we see. Any other sort of private actor who is committing harm to somebody, think about, can the government control this group? Could this person access protection from these government actors after suffering a private form of harm or harm from a private actor? Here is where your country conditions are going to be so important to show what the conditions are in that country. Some countries make it very obvious where being gay is illegal. Like in Nigeria, for example, there's a 14-year term of imprisonment for folks who are seen as doing anything that looks gay, and having consensual same sex. So those are more obvious. That's like, the government is clearly persecuting someone because its laws are in place. Other countries are harder. Other countries nominally might have protections or look progressive. This would be like Mexico or Colombia, for example. But then you want to see, are those laws actually enforced? Do the police actually respect LGBTQ people, or are they more known to harm people when they report instances of harm? So those are things you want to look at for impunity rates or different rates of violence, or if there are protections, specifically people who investigate anti-LGBTQ violence. That's what you're looking at when you're arguing for inability or unwillingness to control. And I don't think I said this explicitly, but it is unable or unwilling. You don't have to prove unable and unwilling. Okay, back to our hypo. So now we're identifying the who. Who are the persecutors in Bernadette's story? Again, I encourage you to type it into the chat, and then if you want to share in the room.
Like people are stumped on the persecutor.
Okay, I will give you a clue that I believe for all of these, they are private. So Bernadette's parents forced them to marry a man, so Bernadette's parents. And then Bernadette's husband, who prevented them from leaving the house, beat them and raped them. Those would be the persecutors for Colombia. So then, because those are private actors, you're looking at what are the conditions in Colombia that show that the government would be unwilling and unable to protect Bernadette if they were to report it. And then in Mexico, again, these are private actors, and including the individuals who called them slurs, but then you could say society at large because of the oppressive, homophobic, transphobic environment that they live in. I will now pass it over to Henry to continue on the different elements of Asylum Law.
Good, thank you, Katie. So Katie just went through the harm that you have to face and the harm, who caused the harm. The next element is the on account of ground, or what judges will often refer to as nexus, meaning why did they harm you? Judges love to say that asylum is not available for folks who just suffered ordinary criminal activity. It has to be on account of or because of one of the 5 protected grounds, which we'll talk about in a second. And what do those 3 words mean? Well, the NIJC says that the race, religion, nationality, etc., has to be one central reason for the harm they suffered. What does one central reason for the harm mean? It doesn't mean it has to be the only reason for the harm. It doesn't have to be the primary reason for the harm. And that's not me saying it, that's the Seventh Circuit saying it right here, and we have the case sites. And the courts have recognized that people can, persecutors, attackers have multiple reasons for doing things. And they can act with what's called mixed motives. For example, a gang may want to hurt a gay man because they don't like the fact that he's gay or that he's more feminine seeming. And they also want to, sell him into slavery, for example, and make money and get free labor. So that's the idea. And you only have to prove that it's one central reason. It doesn't have to be the primary reason. And then according to the Seventh Circuit, it doesn't even have to be the secondary or tertiary reason. It just has to be a non-minor reason. And the ways that we can show this, oftentimes it is the words of the attacker. If they say, for a lot of LGBT cases, they will say some kind of homophobic slur. That's good evidence, but even if they don't say anything, circumstantial evidence and timing. For example, if your client was attacked coming home from a gay pride march, for example, or some kind of event like that, that might be evidence as well. Is this circumstantial evidence? Is someone in town going around and picking off all the people who worked at a specific organization, for all the people who dress in a certain way? Those are ways of showing this nexus. If we go to the next slide, for example, again, this is the Bernadette hypothetical, and I'm curious if anybody has any facts that you would point to if you had to argue that the harm they suffered was on account of their, well, on account they protected them, put it that way. And you can post in the chat as well.
We have from the chat the slurs from the attacker in Mexico.
Yeah, so the slurs are probably the clearest example. If someone's hitting you while they're saying, calling you slurs, it's pretty obvious what they're thinking and why they're thinking it. Any other things?
Sure. The organization that they worked with in Colombia, there might have been a reason that the neighbors found out, or the phone as well, looking into that.
Yeah, that's great. That's timing and circumstantial evidence, right?
Henry, can you repeat it just so people?
Oh,
can hear?
sure. So the answer was the organization, the LGBTQ organization that they had worked with in Colombia, as well as that might be how the neighbors were able to get the photos. And you had mentioned kind of the forced marriage occurring after the photos were being shared. So yeah, it's the fact that for their whole life, their parents hadn't forced them to marry a man until after these photos of them and their girlfriend come out, right? And it's you could also, these are the facts we give you, but when you talk to your client, you can ask them about, okay, when you were going to this organization, did anybody ever hit you on your way there, on your way back? Did they ever say anything about where you were going, or if you were going to that house, for example, right? So just these are the facts that we gave you in this hypo, but when you're actually working with the client, always ask them more questions about what's going on there as well. And for example, maybe when their husband started to beat them and rape them, did they say anything? We don't give you those facts here, but they probably did, the husband probably did say something to them, right? And you can ask them, of course, this is one of those conversations that's hard to have, but it's important to build rapport and ask your client about it so they will feel comfortable sharing the often horrible things that the persecutors have said. So if we look on the next slide as well, this is the protected ground element, and there are 5 protected grounds listed here. These are generally pretty broadly defined, and we would certainly argue that they should be broadly defined, right? Race can mean a lot of different things. And then so can religion. We can argue that it might be because they're Christian, but maybe it's because they don't like the kind of Christianity that they were practicing. I had a client who was a gay man in El Salvador, and people at his church attacked him because they didn't think that he could be gay and Christian. You know, they thought he was being a bad Christian by being gay, right? So you could argue that it was persecution for him practicing a more progressive form of Christianity, for example. Similarly, we do recommend that LGBTQ status and sexual orientation and gender identity definitely fall within the membership in a particular social group category, but kind of as we see more attacks on these types of claims, we do recommend raising other arguments as well. For example, simply existing as someone who is openly gay or openly transgender could be interpreted as a political opinion, right? Or if they have friends, or maybe they don't necessarily appear super, maybe they pass for straight, for example, but their friends in the country were transgender or came across as defined gender norms, or could they be imputed to be supporting LGBT individuals? That's a political opinion claim you can make. But for most LGBT claims, you do want to argue that they are a member of a particular social group. This is the term that is the least well defined under case law, and encompasses a lot of different groups. But in the Seventh Circuit, the only requirement is that it has to be an immutable characteristic, meaning something that a person cannot change, but also should not be forced to change. So the Seventh Circuit has recognized, for example, young women living alone in a country, because young women shouldn't be forced to marry a man in order to feel safe, right? So that's an example of something that you could change but shouldn't have to. And then with regards to LGBT status in particular, generally proving a client's gender identity can often be easier than proving their sexual orientation, because it's you have to ask. It's mostly their testimony about what their experiences, their life experiences. They don't necessarily have a lot of pictures with them and their same-sex partner, for example, if they were coming from a homophobic country. But sexual orientation, I think, is more established in the case law. Gender identity is a little less so. You'll see the case sites at the bottom where they use language that these days we wouldn't really use, or maybe the clients would prefer to use. So we do want to kind of find that balance of using similar language from case law, but also kind of recognizing that times have changed and there are kind of more respectful ways to refer to clients with different gender identities. But generally speaking, sexual orientation since 1990s, this is before I was born, isn't recognized to be a qualifying particular social group by the BIA, which means that's nationwide, and also by the Seventh Circuit as well, which means the BIA can't change its mind next year about it. Sexual orientation can also be imputed, meaning that even if you don't identify as LGBT, you could people could assume that you are. For example, if you have HIV status, if you dress a certain way, for example, there's been nice sort of case law about a woman who wears pants, and in some countries that meant people perceived her as a man or perceived her to be a lesbian, right? So this is generally how you're going to argue about the arguments you're going to raise for the particular social group. And these are definitely very important to articulate these particular social groups in your briefing and make it very clear. So with if we go back to the Bernadette hypo for a second, I'm curious what you all think the particular social groups are. I will say groups for protected grounds, sorry, grounds plural. So it's not just the main one, which you can probably guess based on the topic of this training. If anyone in the room or in the chat has any ideas?
From the chat, we have political opinion, advocating for LGBTQ rights and HIV prevention.
Yeah, so that's great. Yeah, that's one based on their participation in that organization. That's great. Of course, their gender identity and sexual orientation as well would be one. I would also flag that especially if you do have to argue about Mexico, and if the judge thinks that, oh, this temporary work permit was enough for permanent residency, you could argue Colombian nationality as well, because it's anti-LGBTQ and xenophobic slurs, right? So they might have called her some derogatory term for being from South America, from being from Colombia as well. So, and this is again another area that you do definitely want to ask your client about. The political opinion claim helps if you can kind of show a direct timing link for something more connected to their work with the LGBTQ rights organization. But yeah, so that generally, I think, if we go to the next slide, just to summarize here, these are the 5 elements that you have to cover. And again, because asylum is essentially like an affirmative defense that you raise, you represent the petitioner has the burden of establishing all of these elements. So that's well-founded fear of persecution perpetrated by the government, for the reason Katie explained, on account of this one central reason we talked about, and one of these protected grounds. And always try to address as many as possible, because you can't raise them later on when you appeal to the BIA or to the circuit. Whatever you raise in front of the IJ are the ones who stuck with on a particular ground. And again, to reemphasize, these elements are separate. So in your briefing, they should be clearly delineated as separate sections. So you should have 5 sections of your brief on the legal argument side, at least breaking these down. And of course, we can always help with that. We're happy to review your brief. And now I think we've been talking to you for quite a while, so I think now's a great time for a 10-minute break.
Okay, we're gonna just take some questions if folks have them before the break, because we're a little ahead of schedule. So if anyone has any questions, either in the chat or in the room, about all the information that we just covered, how it relates to the hypo, the client best practices that Jules covered, any of that, we welcome those questions now. No bad questions.
Yeah.
Okay, well, we will have more time for questions at the end.
So this next section is what to do once you finally accepted a case. Hooray, congratulations. You've accepted a pro bono client and you're working with NIJC, so here are all the practical steps for getting started. This is a reminder that as a pro bono attorney, you are the bridge connecting your client who has various factors going on in their own life with these 2 or various different agencies throughout this asylum process. So be mindful that this is not the only thing going on in someone's life as they're interfacing with these 2 or potentially 2 agencies who can have a big impact on their life. As we talked about the asylum system, remember there's affirmative and defensive cases, and we are focusing this training more specifically on immigration court defensive cases. That's anyone who is in removal proceedings. And We would tell you, we would identify the cases before you accept them, so you don't have to guess whether this is an affirmative case or this is a defensive case. And as I mentioned before, please don't be intimidated by the idea of a defensive case being a little bit more adversarial. Potentially more adversarial depending on who the judge and the trial attorney are. As I said, you don't have to be an experienced litigator. You truly can go in there learning the tools that we provide you for how to best represent your client, and we'll go through that to give you a better idea of what that looks like. And then if you're more interested, we do have cases that are for at the appellate level, so either immigration appeals or the Seventh Circuit. Thanks, Olivia. What are the immediate steps? Like I've been plugging, please read our asylum manual. It has so much really wonderful information that is really practical for you to take on a case and know how to do so competently. We will send you a case file for that specific client. Please review it so you know all the facts about your client. And then I was mentioning the notice to appear is a document that initiates removal proceedings. And so if that is filed, if your client is in removal proceedings, you'll need to file what's called the Form E-28 with Immigration Court. For anyone who hasn't appeared before Immigration Court before, there is a small bureaucratic process to register yourself. If you could go back, thank you. You can register yourself. It is not that complex. It's not as hard as getting a real ID. It's much more simple. And then you will want to know what are the next upcoming deadlines in my client's case, what needs to be done now, what needs to be done later, and what is the timeline for all these things. Really pay attention to whether their work permit is valid or it's going to expire, or if there's a court date coming soon. I will note that the immigration court is very slow to move to electronic filings. So any cases that are older than, I'd say 2021, are probably paper filings, which means you have to physically file at the court. And anything newer tends to be an electronic case, just to keep in mind so you know how to file and to plan accordingly. Now we can go, okay. These two forms, we're breaking them down because it can be very confusing since they both use the same number. The form G-28 is what you would file when you're interfacing with ICE, with USCIS, the body that adjudicates work authorization, or the asylum office is under USCIS. So that G-28 is very important for all clients, whether they're affirmative or defensive. Especially now, you want to make sure you have a G-28 prepared and signed with a wet signature for all of your clients, just in case with enforcement actions being on the rise, you would want that in case someone were to be detained or to have contact with ICE. And then the Form E-28 is specifically for folks who are in removal proceedings with the immigration court. It is a separate form. I should say too, the G-28 can only be one person entering their appearance. The E-28, you can have primary and non-primary representatives, and you would want everyone to file that as long as you're registered with the immigration court. So you fill out this form and you enter your appearance to tell the court that you should be notified on all communications, and moving forward, we'll be representing the client. Another step that cannot be overlooked because it is so important is completing a biometrics, which means getting their fingerprints done and doing a background check with the Department of Homeland Security. This step is the respondent's burden. It's the asylum seeker's burden to complete, even though it's the Department of Homeland Security who will conduct the step. And if you haven't taken the appropriate steps to have this completed before the asylum merits hearing, they could deem the asylum case abandoned. It is a little bit of a cumbersome process. They tried to make it easier, and so now they're refreshing biometrics, and they estimate that in around like 90% of cases, you wouldn't have to get new fingerprints done. So ask the Department of Homeland Security if they already have fingerprints that can be reused. If not, let us know, and we'll give you some tips for trying to get them scheduled. And then closer to the hearing itself, after assuming they've been completed, you'll want to make sure that they're refreshed, so you're good to go for the hearing date. In immigration court, there is no discovery process. So the way that you would obtain anything the government might have against your client, they will likely not file it either, is through what's called a Freedom of Information Request, a FOIA. And so you can do that specifically with USCIS to obtain, in theory, their entire immigration history. I say in theory because they're not great at disclosing everything all the time, but you want to do it so you can figure out what they might have to try to use against your client, and also to know, is my client's story, has it been consistent throughout? If there are any inconsistencies, how can we account for those? So important to do that. And if your client, especially if you were on appeal, for example, you would want to review the court filings and tapes, anything that's been filed previously. Normally, when you inherit a case from us, we would have filed anything, so you can ask us rather than going to the court, but that is an important step too. And if you're representing an unaccompanied child, it is a distinct process for requesting their file because you have to go through the agency that is detaining them, which is the Office of Refugee Resettlement. Now I'll pass to Jules to talk about what you would do with your client on the first meeting.
In these next couple slides, we're going to go over a little bit of some best practices around your actual meetings with your clients. So once you've accepted a case, how are you managing the meetings you're having with them, the time you're having with them, and how can you best help them to prepare this case? In your case, when you have a first meeting with a client, NIJC will already have done intake for that client. We will have screened for possible relief. We will have probably gathered a lot of information about the asylum claim. We've also likely will have conducted a FOIA process already if need be, maybe not necessarily, but most likely we usually do that. And a lot of that we can provide to you directly. And as a result, when you meet your client for the first time, we recommend that you focus a lot more on the start of your rapport building process with them. Don't talk about the claim at this meeting. Again, it's pretty trauma heavy. That's a difficult thing to get into with someone that you just barely met. And explain what's going on, set some expectations, make small talk, get a sense for what their life is like. Again, in most of the cases that are on the sheet in front of you, there's going to be quite a bit of time between now and their next hearing date and when the hearing is going and when things are going to need to be prepared. And you want to use that time to make sure you're establishing rapport with the client and establishing trust with them, making sure that you can go through all of those extremely trauma-heavy details with them in a way that's going to be the least traumatic for both them and for you. So explain your role, explain your relationship to them, explain confidentiality. This is often something that I think we take for granted because we understand that about our role as legal advocates, but the client may not know. They may not be used to having legal representation. So explain to them that you're not going to share their information, their stories with anyone outside of where you get permission to do so, and certainly not with government agencies outside of here or anything like that. These clients also are often in rather precarious positions. I'm going to discuss a little bit more about that in detail, but this is a good reason to make sure that you are making a roadmap for how you're going to stay in touch with them, how they're going to get to your meetings. Oh, I think I'm going to stay on this previous slide a little bit longer. Thank you. Making that roadmap, how are they going to get to your office? Do they need to get an Uber? Do they have someone drive them? All of that good stuff. You're also going to explain your engagement letter, make sure you're using plain language, especially if you're an interpreter. And you're going to get those forms signed. You can get that wet signature on your G28. That is, again, something that we really heavily recommend, especially given
and Marissa, my boss downstairs.
the trend we are seeing with people who are in renewal proceedings at the moment. Set expectations about the frequency of your communication with them also. If this is a case where the merits hearing is in 2027 and it's currently 2025, you probably want to explain to them that you're not going to be in touch with them every week for the next 2 years. Some clients, again, we're going to talk about this a little bit later, but their priorities are just different than ours. And we need to both meet them where they're at and understand their priorities, but also make it clear that, hey, if an emergency comes up, you can get in touch with me, but I'm going to reach out to you 6 months before your hearing date to really start to work out some of these details.
All right.
Okay, let's hit the next slide. I also want to talk a little bit about, just really dip our toes a little bit into some basics of trauma-informed lawyering. It need not really be said, I think, that obviously asylum seekers are people, or first and foremost, and that their experiences are human experiences. But, you know, as legal advocates, we can often get so wrapped up in the briefs we need to draft and legal arguments we need to prepare and the details and all of this rigmarole around the necessities of building the asylum case, that it can actually obscure, I think, the immediate experience of the people that you are working with and the way that they remember these things and the way that they want to discuss them. Especially, and I know that often our pro bonos don't do necessarily a lot of client-facing work, so it's important to keep this at the front of your mind as you build rapport with your clients and as you work with them. It can be, when working with people who are impacted by trauma, which is pretty much all asylum seekers, they generally have experienced, in most cases, pretty severe trauma. You're going to see things like lapses in memory, difficulty recalling dates, difficulty sometimes, I would say, also meeting scheduling deadlines, other things will come up. All of these are consistent with symptoms of PTSD, and it's important not to take that as evidence of a failure of credibility necessarily. Like if someone says, maybe in the first pass, oh, this event happened in September, and then the next time you come back around to it, they say, well, it was after Christmas. This is consistent with symptoms of PTSD. People who've experienced severe traumas don't necessarily have clear memories of the events, or certainly not of the dates when they happened. It varies from individual to individual, but when something like that comes up, you want to circle back. Don't necessarily assume that they're lying. Most likely this is just a memory issue, and there are ways you can work through that. You can draw out a timeline, say, do you remember, okay, it was after Christmas, was it before your daughter's birthday? What other events were happening? What season was it? And really honing in on these details is gonna help you also to get the facts that you need to build the case, while also just being cognizant of the realities of what people are experiencing. Also, in your communication with clients, they may bring immediate needs to you that are much more precious to them than their affidavit that you're preparing with them. And you should probably be prepared to respond to that, because I mean, often these are very real, even if they do not seem directly related to the case at hand. And lastly, just to note that family dynamics can be quite complicated. You want to make sure that even though you might be interacting with a husband or a partner or a mother or children, and you should also build relationships with those people that are in your clients' lives, and often be in touch with them as well, because suppose someone falls out of touch, you can reach their family members. You always need to make sure to have those one-on-one meetings with your client, and also to prioritize speaking with them as you're navigating sort of complex family dynamics. Some people can be quite insistent about wanting to be in the room with their partner or with their child, and to the degree to which that's supportive, of course, that's great, but at a certain point you will need to be speaking to the client alone, and that's quite important to preserve, especially over video calls. I think that can be quite difficult. I'll go ahead and move to the next slide. Again, in discussing trauma and in discussing where our clients are really at. This is probably familiar to most of you in the room. This is Maslow's hierarchy of need. Briefly, you have to get one rung in order to get to the next, is the idea. So your physiological needs need to be fulfilled in order for you to be concerned about your safety needs. Your safety needs need to be fulfilled in order for you to be concerned about your social needs, like love and belonging. So at the very bottom rung, physiological would be things like food, water, sleep, my immediate physical health, medical care. Safety would be things like employment, like money, financial security, where's my next meal coming from, property, do I have a place to live, do I have a place to sleep? Love and belonging is more of a social need for companionship and family connections. Esteem is a sense of self and wanting to have a sense of respect, and then self-actualization is, ascending beyond the mortal realm, would we all aspire to be there? The point of all of which is to say that a lot of our clients, unfortunately, because of the exigencies of their circumstances, are probably going to be in one of these bottom two rungs of the pyramid. Now, that doesn't mean that we can't work with them, but we need to be aware of the fact that we are asking quite a lot of them when we are saying, we need you to explain your story and your past and your most traumatic details of your history to us in detail. We're gonna create a story out of that, and we're going to bring it before a judge, which is a terrifying prospect, frankly. I mean, I think I would have difficulty doing that, and I'm in a pretty good shape. I don't have to worry about where I'm gonna sleep tonight. So your clients are probably going to be more concerned about their work permits, about their ability to find a job, about their ability to find rent, and it can be a challenge that I think it is our job to navigate as their advocates to say, okay, there are probably some things I can do, maybe, I can help you get your work permit. Let's focus on your work permit, let's make sure that's done. But now we've got this hearing date coming up, and in order for you to be safe and to have status in this country, we need to try and fight for your asylum case. And that involves us finding a time for us to sit down and talk through some of the worst things that have ever happened to you. And the ways that you can make that the smoothest possible process are to just be cognizant in your scheduling, help them get transport if they need transport. Make sure you're scheduling around things like maybe their children's school schedules and trying to make things as easy for them as possible so that they can feel comfortable coming to you and getting into really, really deep and difficult topics. This is also why building rapport is just so crucial. And lastly, I'm gonna also talk a little bit about working with interpreters, which is something that I've done quite a bit of. Even if you have language competencies, you may end up working with someone who prefers a different language, and so it's important to keep this stuff in mind. You also may be working with an interpreter in the court setting. So NIJC can be a contact point for referrals to find interpreters, but we don't do this for you, so it would also be your responsibility as a pro bono to set this up and also to arrange compensation for an interpreter if you were finding a paid interpreter. A couple of things to keep in mind. Always make sure that you're working in your client's preferred language. We often have folks from, for example, Central America who probably speak Spanish, but may prefer to speak an indigenous language, like Ishu or another dialect of Maya. And so check in on that, make sure that you're working in the language they work with. I will say for LGBTQ clients, what we sometimes see is if they have multiple language competencies. I'm thinking, for example, of a Kyrgyz client I had who's from Kyrgyzstan, who spoke both Russian and Kyrgyz, which is very common there. Kyrgyz would be his first language, but he's quite fluent in Russian. And he actually preferred to work in Russian, in part because he was worried that a Kyrgyz interpreter would be homophobic. And also in part because there are better interpreters available for a more commonly spoken language like Russian in a court setting. So that's his decision to make. And that's another conversation to open up with your client and to navigate there. If you're in a client meeting with an interpreter, talk to your client, make eye contact with the client, don't speak to the interpreter. Ask shorter questions, try not to use compound phrases or sentences, it's more likely to get lost in translation. And make sure to schedule in breaks, which is a good thing to do anyway, but especially interpretation can be quite exhausting. It's kind of, when I have to do it, find it to be kind of like running a sprint and a marathon at the same time. So just take things in short bits. And we really value our interpreters and they do really good work. And there's also some resources here, some great trainings that NIJC put together on more details about working with interpreters. Before I hand it off to my colleague Henry, I also just want to put in a small plea, which is that in looking at the pro bono work, the case notes that are in front of you, I'm thinking back very fondly on having done intakes for a lot of those folks in my time at NIJC, which is one of my obligations there. And I am thinking about how fondly I feel towards those clients and the work that was put into making sure that cases are prepared and ready to go. And I really hope that some of them get to find some very dedicated legal advocates here. But I'll hand it back to Henry to talk more about preparing the case.
For that, and yeah, it is really important. It really is kind of like for a lot of these clients to be able to have someone represent them and prepare their case law. That's what we're going to talk about next. Before you have the hearing in front of the immigration judge, you're going to have to prepare your filing and submit it, usually now 30 days in advance of the hearing. and here we'll just kind of give you a brief overview kind of what that filing can entail. So on the next slide, we really break it down into 3 buckets. So we have the client's affidavit, which is the statement explaining their story that kind of Jules was giving you advice about how to prepare. And then we have corroborating evidence. So that just kind of that can be a lot of things. It's medical reports corroborating that the scar on their arm was in fact from being assaulted, or that they had PTSD, for example. Police reports to show they went to the police. Oh, everything okay?
We're having some audio issues online. I'm wondering, let's just pause for a second to try to fix it. I think it might be.
Is it, am I covering something?
I think the mics are in the ceiling somewhere, yeah.
But they can't hear us.
They said they're getting a lot of background noise, like rustling papers
That
or
might be what it
movement
is,
in
yeah.
the room.
Oh, man.
Is it sounding better now online, folks? You may have to try to really project and be as
Sure.
minimize rustling as
Yes,
much as you
it
can.
I think better.
Okay, great. I will talk louder. Usually people tell me to be a little quieter, so that's fine. I will allow this. Yeah, so corroborating evidence, that can be both corroborating your client's own story, so documents showing that they in fact went to the police, or they in fact were injured, that helps convince the judge that they're telling the truth. Corroborating evidence can also be corroborating the condition of the country. If you have evidence showing that in that country X is very homophobic, and even though maybe they pass same-sex, like same-sex marriage is illegal, but there's hundreds of LGBT people being murdered every day. That was something I had to deal with in Colombia.
Unless you have like key lamps.
And then the third kind of part of your filing is probably what you're most familiar with as lawyers. It's legal argument, it's your brief that you're gonna
But
prepare.
otherwise typically.
And that's
let me
writing out
ask
this
her
argument.
about
That's
that.
you're probably most familiar with from law school research and writing classes. So first we'll just address the affidavit, because it really is the key part of your case. Your client's asylum case is going to rise and fall based on what happened to them, right? So it's their story. And credibility is really important, because if the judge doesn't believe your client, then kind of everything else really does fall away, except in some rare circumstances where you can win a case just on corroborating evidence. Most of the time, the judge doesn't believe you, then it's really, really hard to win the case. And judges make credibility determinations based on a lot of things, like demeanor, candor, how inherently plausible they believe the story is. The big thing is how consistent their affidavit is with what they tell their testimony on the stand in court. Or, for example, a lot of clients come through and have what's called a credible fear interview when they first get to the border. How consistent are they saying things? Are they saying, telling completely different stories? That's one way a judge might find them adversely credible. So really, this is really important. And if we go to the next slide there, yeah, so again, as Jules mentioned, most, or not all probably, clients are trauma survivors, and it can be difficult for them to explain their story in a way that makes the most sense to us lawyers or judges who kind of think of things in ways that are not perhaps the ways that most asylum seekers think about their stories. So yeah, they might get dates mixed up a little bit. They might not remember the exact order of the events. They might leave out stuff until later in the time when they actually maybe have more trust in you and they're willing to disclose kind of the most horrible things that happened to them as children, right? So we really do recommend that you prepare for these meetings in terms of you have an idea of what you want to discuss with the client that day. You say, today we really want to talk about your childhood and what happened there, and give them some options, saying, is that okay with them at the beginning of the meeting? Give them a sense of, this is what we're going to talk about. If you really can't handle talking about that today, maybe we can talk about something else. Maybe we can talk about, less traumatic stuff at first. Just giving kind of, these are folks who've had very little agency or control over much of their lives and much of their decisions in the last few years have been reacting to horrible things that have happened to them. So just giving them any kind of sense of empowerment, control, agency in telling their story is helpful. Also, especially with LGBTQ clients, kind of explaining why you're asking these questions, right? The nexus part of an asylum claim can be really confusing for a lot of clients. I've had clients who really want to tell me about kind of this horrible thing that to them that was really traumatizing to them. And I was like, that is really horrible that you were robbed, but it's not the focus of our case because we really can't connect that to your sexual orientation, right? So kind of explaining why you have to ask these questions, especially when you're asking about someone's personal life and sexual orientation, their gender identity. It's difficult for folks to talk through it. Still having issues?
Yeah, still having issues with sound.
So we're trying to fix that. The challenge is the room is split up into two and they're setting up the other side. So there's some people who are setting up. Let's take a 3-minute break and we'll try to fix the audio and then we'll jump back in.
Right.
Was there no other microphone
Yeah, was
here?
there like a little, it's like.
Yeah, it was on the. I don't know if they got
Oh.
but we weren't using it.
It was confusing because on the chat, they're like, there's so much talking. And we're looking at the room and we're like, it's silent.
I don't know if they were gonna use it.
Okay, can we check now? Folks online, is that better? Are you able to hear us better now?
Yes, better.
Amazing. Great. Thank you for problem solving, everyone.
Thank you.
We need to mute the room ones though. I don't know how to do that, sorry.
And now, can you all hear online now?
Audio is back. Yes, yes.
Okay. There's still rustling in the background or other voices for folks online?
It seems like we might be in a better spot now.
Clear,
Yeah.
yay.
Okay.
Okay.
Let us know if that changes, folks online. Thank you for your patience.
I think we're good.
I gave him a handheld.
Okay, yeah, we have one here.
So then that was the seal. Yeah, great. We should be good now, sorry, yeah, okay.
All right, thank you. Well, I'm glad we got that worked out because I have no idea what to do with technology. So thank you very much. Where were we? Oh, okay, right. So on affidavits and interviewing trauma survivors, one thing that I've encountered kind of with my cases is that judges and ICE prosecutors really care about chronology and kind of like when this happened, where it happened, kind of those things. And that's very difficult for asylum seekers. So it really does take a lot of kind of talking to them in sessions to really help them then figure out the timeline of the story. Sometimes when you've been horribly sexually assaulted so many times, it's difficult to remember each and every incident, for example, but that's what judges kind of expect. They expect you to recall things like that. So really helping your client prepare for that so that these difficult questions that they are going to get, especially now, you don't want them to be answering those questions for the first time on the stand in front of an immigration judge, right? So you want to kind of have these conversations with your clients. And then because these are difficult topics, we do recommend bookending the interview, which just means starting off kind of, as Jules said, ask them about how their day was, small talk, really just build rapport, and then kind of work up to the most traumatic thing, and then don't end with that, and then just send them off on their day, right? Kind of ask them some other things, maybe a little lighter. Something we always put in the affidavit is like, what are your hopes and dreams for why did you come to this country? What do you want to do in the next 5 years, 10 years? You can ask them about that. You can ask them about how their children and family are doing. Do they have any plans for the weekend, for next week, things like that, to kind of make it a little easier at the end of the interview. So it's not so difficult for them every time. But it is a challenging experience. And I think it's one of the hardest things, at least in my experience, working with clients, just really being able to work with them, get the story straight and work on these affidavits. So next slide is, just some other considerations. This is more as you're writing. So again, make sure it's in the client's voice. Don't use legalese, that's for your brief. Again, chronological order in the affidavit is just really important for immigration judges. For any incident of persecution you want to cover, who did it, where it happened, when it happened, why it happened, especially for that nexus element, and then how it happened, right? So that those are kind of what the judges are looking for. Again, cover all the asylum elements. Any kind of persecution you want to connect it, if you're going to put it in the affidavit, connect it to a protected ground, explain why you think it was because of their sexual orientation, right? And with length, we usually see about 8 to 12 pages for affidavits, depending on, how many horrific things have happened to the client and how, how complicated their story is. Too sparse is, if it's only 3 or 4 pages, it's not that helpful. A lot of judges will don't like clients telling a lot more on the stand than, for example, was in their affidavit. But you don't want a 20-page affidavit that explains everything in great detail because the client's not going to be able to remember everything on the stand. So on the next slide, we kind of have an example of like how to find that balance, right? So one thing is to not use language like legal terms like persecuted or belonging to a particular social group. But at the same time, you don't want to, clients have different levels of sophistication. I've had clients who had degrees in their home countries, right? We even have clients who are lawyers in their home countries, right? So they're going to have a very different way of telling their story than other clients who maybe only went to a couple years of elementary school and then were forced to drop out because their parents didn't want to pay for women to go to school, right? So again, it's very different. So adjust that as you write the affidavit. It's really meant to be in the client's voice, not to, certainly don't say see tab 4 of the human rights report. That's not the way anybody talks when they're telling this story. And then the last thing we want to flag, this is not too much detail, right? Kind of as Jules has said before, a lot of clients won't remember the exact date something happened. A lot of clients actually do because it's a horrible thing and they remember very clearly that like June 5th will always be a horrifying day for them. But many clients will just say maybe it was winter, it was sunny, it was warm, right? So not putting the dates in and then expecting the client to be able to recall that. So kind of the last one we would say, instead of saying May 1st, say May, or say spring. Instead of saying 3 gang members, just say a group or several, things like that. So you have an idea, but the client has a little bit of wiggle room when they actually have to testify. The next part is corroborating your case. And on the next slide there, usually the regulations state that corroboration is required unless you just can't obtain the evidence, can't reasonably obtain the evidence anyways. You can win just on your client's testimony, but especially in this day and age, I think that gets harder and harder. So any kind of evidence that shows what your client is saying is in fact what happens, any documents that support their version of events really does help. And if you're not able to obtain those documents, just explain why. For example, maybe there's no police report because the police laughed at your client and told them to go away. That's what happened in one of my cases, right? That's why we explained that the unable or unwilling. I can't produce a police report if the police told me to get out, right? So if you go to the next slide there, there are different kinds of corroborating evidence. Kind of as we explained before, there's country conditions evidence. There's more about the general state of things in the country that is especially relevant to LGBT clients, showing that there's widespread persecution or widespread homophobic attacks, for example. And then there's client specific evidence that includes like what physical evidence of their injuries, maybe affidavits from their family or friends stating that, yes, I will swear under oath that this in fact did happen, right? And then the evidence can relate to both past and future persecution, past persecution mostly being kind of, again, showing that they did suffer injuries, they do have PTSD, they did suffer mental or physical harm in some way. And those can include medical reports from experts, from doctors, psychologists who you can contact for future persecution. You can also get experts on the country itself. There are folks who have PhDs in Latin American studies or African studies or things like that that can attest to how things are in certain countries because they've done research about it. So that's something that is important as well. With regards to kind of the country conditions evidence, as we call it, generally, traditionally in immigration court, there have been these human rights reports that the Department of State puts out on an annual basis about human rights practices in most, if not all, countries around the world. The Board of Immigration Appeals usually has stated in published case law that they think of these as the gold standard and kind of are highly probative. So to the extent that these reports are corroborating what your client is saying about how horrible things are in their country of origin for LGBT people, do cite to it. But we are pointing this out because starting earlier this year and with this administration, there's been reporting that these reports will be edited, written in such a way to exclude information about LGBT individuals, women, folks with disabilities, and a lot more. And the link is at that. We do have the link on this slide here. You really do have to be prepared for these reports to not be as helpful as they might have been in the past, or for these reports to perhaps say, oh, everything in Guatemala is wonderful. It's the best place in the world. Everyone should move there now, right? If that does happen, fortunately, the Seventh Circuit, as we put on this slide, has noted that these are Department of State reports. So what are they? They are authored by folks who are mostly concerned with the United States relationship with that country, and they're not the gold standard as the BIA thinks of them. So we do offer these case sites to kind of have in your back pocket in case the ICE prosecutor tries to introduce these new reports that say kind of things are great in your client's country, for example. So I won't read the quotes, but you do have them there for reference. So kind of, we do have some tips on the next slide for country conditions research, especially if these reports from the Department of State are going to be less helpful or less candid. We recommend these other organizations right here, listed here for LGBTQ individuals in particular. And then with advice on, we do have some advice for different kinds of countries. One you'll see is kind of the countries with mixed conditions, kind of maybe Mexico or Colombia, where the laws might seem great, or there might be places, there might be cities where the news is saying that like it's a great place to travel for LGBT Americans looking to go on a cruise or something like that, right? And you do want to kind of look for other evidence suggesting that like the positive press that is out there is maybe not reflective of the what a person actually from that country, often from a lower socioeconomic background who is not a tourist, might experience there. So especially if you can look in the local language, that's more helpful than honestly what you'll see in a lot of English language reporting. On the other end, there are countries where it is so unsafe to be openly LGBTQ that there's just not any reporting on it because nobody wants to talk to other people about being openly gay. And in a lot of African countries, for example, where it's still illegal, where same-sex activity is still illegal. So in that case, sometimes if you look at one method we've had is just looking at like the major newspapers in that region and looking at all the anti-gay or homophobic reporting and columns that have been put out saying, oh, like this is decadent Western values ruining our traditional society, that kind of thing. That may be a way of showing like these beliefs are so common and so pervasive that it's just people are out there saying this publicly in the newspapers and being proud of their columns saying these kinds of things. Similarly, we do recommend kind of getting expert witnesses for most cases, but especially for these two types of cases with the mixed country conditions ones and the ones where it is just so incredibly dangerous where you can't find anything. We do have recommendations. You can reach out to us. There's also the Center for Gender and Refugee Studies. It's another organization that does have recommendations for academics and folks who are who have done research in those countries can attest to the conditions there. And then if you're still struggling, you can always ask the client themselves. A lot of LGBT clients in particular might have some knowledge of smaller local organizations that might be able to do some reporting or at least get you in touch with other people who might connect you with an expert, for example. So country conditions research has been increasingly important. And with working with experts, we do recommend that where possible to get an expert both to explain the conditions in the country, explain why, for example, it's not reasonable to relocate somewhere, or the Seventh Circuit in some decisions has said, oh, like you went to the police and the police ignored you. This was just one bad apple, right? So you want country conditions experts or other evidence saying, no, it's not just one bad apple. This is consistent across the country. That they can't just find another police officer that's going to be willing to help. So that is really important. And again, we do have referrals for that. And then the other thing we do want to touch on is mental health experts. We do have recommendations there for folks who can kind of explain that, oh, they might not have suffered physical injuries. They might have all their limbs, but they are really dealing with horrific PTSD or mental harm. So just back to the Bernadette example here, does anybody either in the room or online have any suggestions for corroborating evidence that we might be able to get for this case? I know it's been a minute since we looked at the example. Sure, yeah.
If they filed a police report after they were robbed.
Yeah,
I want to repeat that now that you're using.
sure, yeah. So the response was if Bernadette filed a police report after they were robbed in Mexico, yeah, that would be great. Way of corroborating what they said. Any other ideas? Sure, yeah.
Maybe the marriage license.
Yeah, that'd be great, right? Marriage license to their husband showing that they, again, were forced into marrying someone that they didn't want to. At least that they were married, right? And then corroborates their account. So yeah, some other evidence you could always try to get, for example, you could contact the sister or the girlfriend in the home country and ask them, hey, are you willing to talk to me on the phone or on WhatsApp for a couple of minutes? I'll write up a brief statement, and then you just read it over and sign it. I'm doing that right now with one of my clients' sisters. If they have any records, if the LGBT organization has a website or any flyers proving that, again, this organization exists, again, corroborates the story. The photos of Bernadette and their girlfriend, if they can still get them, again, that's very helpful proof. Marriage license we talked about, police report we talked about, the Mexican work permit showing that it in fact had an end date. That's a good way to show that it's not an offer of permanent residency if it has an end date. And then you could always try to get an expert with a PhD in like Latin American studies or something for Colombia or for Mexico as well. So those are some options. And lastly, the last piece of your filing should be the brief. And if we can go to the next slide. Okay, I'll try to keep this section a little shorter. I'll keep it brief, huh? Because folks know how to draft briefs. I think y'all are very good at that. Again, first point, really, you do want to keep it within 25 pages. We've heard of immigration judges who will not read the brief because your signature page is on the 26th page, for example, like that. So do be careful, check with us about what these kind of like requirements with the brief. Again, when you're writing these, you do have to do a lot in 25 pages, right? You have to have a statement of facts, explain the country conditions, address each element, not conflate the elements and things like that. So really, it's a good way to practice concise writing. So with case law, focus on 7th Circuit case law. If your case is in Chicago or in Indianapolis, if it's not, again, look at the relevant circuit. Preserve all arguments, raise all the particular social groups you can, use footnotes if needed. Do send the brief to us for review. We do have a team that will look over your brief, that will give advice on it. I've done that. I don't know if I'm always qualified to do that, but I have done it. And yeah, definitely, what was the last point? If you're going to ask us for help, please do give us more than 24 hours. Don't send it, if your brief is due, April 1st, don't send it to us on March 29th and expect a response by March 30th. We're sure you're great writers, but just want to have a little more time to really read through it and give you feedback and rather just be like, looks good, So there's that. And that really is all we do have sample briefs we can circulate as well, so you don't really have to reinvent the wheel or things like that. So reach out to us. We're really willing to partner with you on this point. And then the next slide. So those, again, you've got the affidavit, the corroborating evidence, and the brief, and that's your legal filing. But there is more to do in the case besides kind of just everything for the merits hearing. While the case is pending and while you're working on it, remember that you should be working on kind of all three of these things in tandem. It's not so much that you spend 2 months on the affidavit and then you do spend 2 months on the corroborating statement, and then you spend 2 months on the brief, mostly because things that you need from other folks are going to take a while. For example, if you're trying to get evidence from the home country, that can take a while, especially if you need to get the original, you need to get it shipped here, that can take a long time, right? But even getting in touch with family members, being able to speak with them, draft an affidavit, drafting the affidavit with the client. I've never done just one session with a client. I don't recommend it. I think it's a lot. So it'll have to be probably several sessions over several weeks. We know you have your own cases, and you should kind of be working on all of these things in tandem because they will influence each other. For example, as you work on the legal research and writing, you know what questions are important to ask your client. As you ask your client more questions, you realize, oh, maybe I should explore this argument. For example, I have a case now where it's a domestic violence case mostly, but from talking to the client, I realized that a lot of the impetus was because she was pregnant and her husband didn't want the baby, and her husband wanted to force her to get an abortion, right? And she didn't want to. So kind of that wasn't something that I knew until I asked her more about it. And then that raised another protected ground, a political opinion ground unrelated to kind of her gender arguments as well. So definitely work on things in tandem, connect your client with a therapist or other mental health resources, both for the good of the client and to help them prepare for testifying. Really do check in with your client regularly, even if you've done the affidavit and you don't need to talk to them as much anymore. Take a moment just to make sure that their phone still works, because you know sometimes folks who are kind of living paycheck to paycheck, their phone gets disconnected or they move, and you do want to make sure you know if they move, because you have to update the government if they do. Let us know if you're having trouble getting in touch with your client. And perhaps most importantly, and we'll go to the next slide for this, is to get their work authorization while their application for asylum is pending. After 150 days pass after the asylum application was filed and it still has been adjudicated, the applicant is, as of now, currently eligible to apply for a work authorization. There are some issues there. The clock this kind of 150-day clock does stop if the judge believes that the applicant has caused a delay for whatever reason. So do check with us about it, but generally you can, in about 6 months, you can file a work authorization for a client. And for your client, other than getting asylum, this is probably the most important thing for them, because a work authorization means they can support themselves. They can get a job that, you know, isn't working under the table. If you don't have work authorization in this country, and I did not for my first 10 years in this country, it really does make you a lot more vulnerable to kind of labor abuses in the jobs that you are able to find. Or for a lot of folks, it makes you more vulnerable to domestic abuse because you have to depend on a partner or a family member and things like that. And it really does kind of make their life a lot more difficult. So this is something where kind of, as Jules was talking about, those first two rungs on the Maslow's hierarchy of needs, this is really important for them. And for the attorney, it might be more interesting to work on the brief and crafting interesting legal arguments, but this really will make a huge difference in your clients' lives. And we really, really emphasize doing this in a timely manner. Lastly, kind of on the things while your client's case is pending, is just make sure to have them keep you in the loop if they become eligible for other forms of relief because their life changes. If they get married to someone, for example, that might change. If they get married to a US citizen, that changes things. If they get married to someone who isn't a US citizen, they might be able to include that person on their application for asylum. If they have a new child, again, that's a US citizen child, that might change things. If they become a victim of a crime, that might qualify them for a certain kind of immigration benefit outside of asylum. But definitely check with us before you file anything. Your clients should not be filing for any other immigration benefits without consulting you first. And you definitely shouldn't file anything without just shooting us an email and letting us know things have changed, just so we can help you kind of make sure that everything goes well with the asylum case and with your client as well. So I think that is it. I know that was a lot of information, but hopefully it was helpful. And Katie will now close out to talk about presenting your case in court.
Yes, this is our last section. So this is what happens when you're actually in immigration court. What are you filing? What does that look like? And what is happening the day of the hearing? So what to file, Henry gave a very thorough, very helpful explanation of what you're filing. It includes your notice of appearance, which is the Form E28, the asylum application. Those are likely already on file. And then the brief, the affidavit, any sort of amendments that you're making to the I-589. People's lives change, and so their addresses have probably changed. There might be other things that you're updating. Please don't send amendments to the I-589 like in the moments that they're happening. It's usually best to submit that all together prior to the merits hearing, so you're not raising flags of potential inconsistencies. There might be things or explaining why something maybe is slightly different than it was phrased before. You always want to be thinking about credibility, because they will try to use any sort of detail that changes or inconsistency against your client. So be paying attention to all that and confirm the information in the I-589. Annotated index, which has all of your corroborating evidence and including all of the country conditions, and then any other support of that will be highlighted in the supporting documentation that's included. You have to serve a copy of everything to the government. remember that if it's online, that is serving the government. But if it's a paper file, then you'll have to go to the court. So make sure you're planning ahead with your filing deadlines. What does our annotated index look like? This is a sample. So you'd have the affidavit, you would have letters of support, proof of identity. That is important. You want to make sure they believe your client is who they say they are. And then all of the background information supporting the claim. As you'd see, you'd pull out any sort of quotes that's more important for the adjudicator. We can't always trust adjudicators to read everything, especially when we tend to submit very robust packets of 400 pages. So you want to bring attention anything that you don't want them to skim. You want them to actually read. Oh, and I should say NIJC has a database of country conditions for LGBTQ clients. So contact us as a starting place, and then you can tailor that to your client. We use these for pro se folks, but you can individualize it and have at least a strong place to start when you're preparing your case. The filing format, the be all end all, look at the immigration court practice manual. They might change it sometimes, so always go online and check what is the practice manual saying these days, so you can adhere to those. And then know that there's a 30-day, the default is a 30-day filing deadline in advance of the merits hearing. Judges have their idiosyncrasies, so check with NIJC if there's a certain formatting thing that a judge has said that they want that's outside of what exists in the practice manual, so you're not getting rejected based on one of those preferences of a judge. You want to highlight anything important, as I said, so you're drawing the eye to anything, and you don't want the judge to miss over important facts. And I already beat myself with the other information. So for the merits hearing, this is a layout of what the courtroom looks like. It is not, like I said, like a formal hearing in many ways. Your client is often sitting next to you rather than going to some witness stand in front. And so then you have the judge and then the trial attorney by your side. You want to prepare your client for this day, tell them what this layout looks like so they know what it looks like. This is if you're in person. You might also have a hearing on WebEx, which is fairly similar in theory in the layout. And then while you're doing the affidavit drafting even, before you finish your filing, you should probably start doing at least some preparation for direct exam so that the way your client is answering and putting information into the affidavit is consistent with how they would respond to questions when they're in the hearing itself. You want to do practices, multiple practices, so that your client gets used to and comfortable answering these questions. We say to do one that is, you know, how you would be asking the questions, one that is tougher because some judges like to interject and take over questioning themselves. So you want them to be prepared for that. And one that's a confidence builder, maybe like making them feel very good about themselves or asking fewer questions so that they just know that they know their material. They know that they can confidently convey the reasons why they merit asylum on the day of their hearing, because anxiety affects everyone, especially if you're testifying, and especially if you're testifying about particularly traumatic events. Explain to your client so they can expect all of this, all of the logistics. Normally, you don't have an opportunity for an opening statement. You go and you do the administrative procedure of admitting things into the record more so, and then you kind of switch directly into direct. The government has opportunity for cross, and you have redirect and then closing statements. Have your client be prepared to know what that is and what that looks like. And also make sure your client knows the asylum elements that we talked about too, so they know what are the points that they need to really make sure they express when they're doing their direct exam. What are the things that the judge would be looking for that will have the most impact? It is very important too, as I said with credibility, that they know that they can say, I don't know an answer to a question. I don't understand what the question is asking, especially with the ICE attorney's questions that can be intentionally confusing or trying to trap someone. So really empower your client to say that they don't know, that they don't understand, or that they can repeat the question or ask it a different way. It is their moment to tell their story, and so they should feel like they can retake control to the extent that they can so that they can understand and respond to the questions being asked them. How to prepare yourself for the actual merits hearing. As I mentioned, you'll want to reach out to the opposing counsel so you can get their position. You can confirm that they received all the documents that you filed. In this administration, probably less likely to get a response from them. But they should tell you whether prints have been refreshed. You should do that at least a month in advance of the hearing to make sure background check won't be a reason for pausing the hearing or not being able to issue a decision. And then ask us. We can share stories about experiences we've had with your specific judge, with your specific trial attorney that can help you better prepare so you know their style and what to expect on that day. One more plug for the procedural manual for asylum representation we have on our website that has a really helpful database, and then also, on our website has a helpful database of examples of direct exam cross. We have examples of expert testimony, examples of closing arguments, and just so you know, sometimes the judge will issue an oral decision the same day, or sometimes they need time to think about it and will issue a written decision. After the merits hearing, if asylum is granted, congratulations. It's such a great thing, such a happy feat. Let us know immediately. There are more steps for continued representation in order to make sure they have proof of their asylum status and that they can obtain all benefits that are available to them. One of those is the I-94, which proves that a person has been admitted now under the status of asylum. And then they can get work authorization under their new status. They can get a social security card that's not restricted and other benefits. So this is part of representation that needs to be completed before you can close out the case. And then also let us know if they have family members who are in home country who could now benefit from a petition for them, or if there's other forms of relief, meaning residency, when they would be eligible for residency in the future. Asylum denied. This is always a possibility. And so if this were to occur, you want to reserve your right to appeal the decision. You have 30 days to decide if you are appealing the decision. So in that moment, if it is denied, reserve appeal. And let us know immediately, and we can talk about what the process would look like to appeal to the Board of Immigration Appeals. So as I mentioned, we have the list out in front of you, and I believe it's going to be emailed out as well, of the 8 cases that our goal is to place today. Take a look at that. Let us know if you're interested. Our ideal model for placing cases is with a pro bono team, probably of 2 to 3 attorneys who can take on representation of a case. And then one of those attorneys, it's usually preferred if they're local, that could meet with someone in person if need be. So here in Chicago, one person could be here to do any sort of logistic things that need to be in person. And then you'll be paired with one attorney from NIJC who will provide the technical assistance throughout the remainder of the case. There is the contact information. If you see a case that piques your interest and you want to accept it, you reach out to our amazing coordinator, Moises. And what can you do? Here's other ways to stay involved and stay informed. We have a newsletter that we encourage you to sign up for, subscribe to, so you can get updates on the things that are going on in the immigration sphere with NIJC. Check out our case list. You can contact us if you are interested in a case, and we always encourage donations. Before we have questions, or while I let you gather your questions, I will give our final CLE code, which is the word rainbow, RAINBOW. Again, that's rainbow. I believe you need to scan the QR code in order to process it. If you signed up in person, we have your information. But if you are online. You will get a survey to fill out, or you can scan the QR code here. Again, the word is rainbow, RAINBOW. And now, any questions in the room or on the chat?
We covered a lot of content.
We
There
did
must be
cover
some sort of
2.5
questions.
hours of content, so. Brilliant. Oh, yeah.
So I believe it was mentioned earlier that the burden of proof for a child's case of a kind of like their social group being LGBTQ plus is lower than for an adult.
Mhm.
How often is it that with children it seems that they kind of adhere to the social group, or is it kind of less often than that's seen?
A great question. So that was about the burden of proof for children versus adults. So specifically that's for persecution. So the harm that they experienced, whether that's severe enough to meet the level of persecution. And what the case law says is you have to take age into account when you are determining whether this rises to the level of persecution. It happens a lot. And it's what's really important. It doesn't matter the age of someone now. So say you're now an adult, but you experienced harm as a child. They still have to factor in that harm as a child at the time that it occurred when they're doing that cumulative analysis of all the harm that they experienced in their life. And unfortunately for many of our clients, or at least many of the clients I've represented, there is some history of childhood sexual abuse. And so people might think, oh, that's not relevant because it happened so long ago. And what we should focus on instead is the thing that immediately forced them to flee their country. Please don't exclude anything that happened in their childhood because you think it's so long ago. That's important, that's relevant, and that matters. And that matters to the cumulative factoring in. So that's a really great question. Thank you.
We received a question in the chat. Maybe I'll just come up there and read it so you don't have
Okay.
to repeat. We received a question. Do you ever have clients whose understanding of their own sexual orientation or gender identity changes over the lifespan of their case? If so, how do you handle that?
You want to do it, Jules? You can.
You can.
You mean you?
Yeah, thank you for bringing this up. This is something that we do see often. This is something that's very common for people, for anyone to come to terms with their own identity in different ways over time. And one way that we might account for that is to check in with them. If you haven't spoken with someone for a long time, just check in briefly about things like names and pronouns. Or sometimes clients will volunteer information about, well, I've started a gender transition, or I'm going to be taking hormones now. And making sure that you are cognizant of those changes as they happen. And also when names change like again, that's okay. And you just do the same thing. You just start using the new name. That's not actually all that uncommon. A lot of people, they might choose different names before they settle on the one that they like. Or they might change their mind at just some point. And it's totally, I mean, that's just, you can just do that. Anyone can do that, really. So it's our job as legal advocates then to take that information and to explain it to the court if it's relevant. Maybe offer some resources on things like name changes. But that is something to be aware of as you're working with queer clients, is that because someone identified as, this is a common example, if someone identifies as a gay man, and then she comes back 2 years later and is like, I'm actually a trans woman, which is just a really common thing that happens. A lot of folks, it's for a variety of reasons, a lot of folks might feel themselves to be part of one part of the community and then come to terms with something later, maybe once they're safer also. Once they get to the US, they might have more options. So this is something to keep an eye out for, and also something that you can absolutely explain to the judge, and you should. It's not going to disqualify anyone. Go ahead.
Thanks, Jules. One other question that came up is, do you have any tips for getting corroboration from a client's home country? Whether that's communicating with friends or family or getting records, how would you go about that?
Great question. It really is so case dependent. And so it takes a lot of communication with your client to figure out what is reasonable, what is accessible. Definitely, if you have resources as a firm, you might be able to tap into those to obtain things that might be unsafe for your client to do themselves, and navigate what is possible to get. Anything that is not possible, not safe, not available, you want to keep that in mind too, and have reasons why, because part of the case proving that you can corroborate the case, if a judge says, well, you didn't have this, and so I'm denying on this ground of corroboration, you have an opportunity to explain why it wasn't available, why it's not reasonable to obtain that. So you want to preserve why an asylum seeker, someone who's fleeing their country, is not able to get a document or some sort of corroborating evidence. Any last questions? Okay, I think we'll call it. Thank you so much. Thank you to McGuire Woods again for hosting. Please reach out to us if you have questions. Charlotte, you want to do a quick close?
Yeah, I'll just close out by saying we're really grateful to everyone who came in person and who registered. If you have colleagues who you think would be really interested in this, we would love for you to pass along the materials to them. And as we mentioned, we did not expect anyone to leave this feeling like an expert in asylum law. Like, the whole point of this training, or in working with LGBTQ asylum seekers, the whole point of our model is that we can support our pro bono network in client-centered, trauma-informed advocacy, and we really need the folks in our community to help us be able to serve as many people as possible. So if you left today feeling, we hope you leave today feeling like you understand vaguely what it looks like, what some of the elements are, what the process would be, but not that you're like, I can go do this on my own. We don't want you to do it on your own. We want you to do it with the technical assistance that we provide and the expertise that NIJC has built in this area. So as I mentioned, we will follow up via email tomorrow with both the CLE materials if you weren't able to fill it out just now, and also with the case list of cases for which we're seeking representation. These are the LGBTQ asylum cases that have merits hearings scheduled in the upcoming year. We also have a number of other cases always seeking representation. So if you have questions or a certain timeline that you're looking for, we are happy to help with that. And again, just thank you all so much for dedicating your time to this and learning a little bit about our clients and what we do to serve them the best way we can. Thank you very much. And for those of you in person, we have a reception right next door. And for those of you online, we hope you have a restful evening. Take care, everyone.